appeal in the matter of AM and another versus the Secretary of State for the Home Department.
Yes, good morning, Mr. Greer, Ms Barnes. First thing before I forget is that Lord Justice Zaccaroli made an anonymity order when he gave permission. And unless anyone objects, it seems to me that we should continue it. News about that?
No, my lady.
No, all right. But can we please be very careful that we just use initials rather than names?
Yes, my lady.
Second point, I don't know, Mr. Greer, whether you know, but Ms Barnes has asked whether she can take a break at some point during the hearing this morning. We're very happy for that to happen. But could you just indicate to us when it would suit you?
Yes, of course.
To do that?
And thank you.
No, not at all. And the other thing that follows from that is, would you prefer to make your submissions sitting down?
That's kind of you to ask. I think I'd probably prefer to stand up, but if I'm losing energy halfway through, perhaps I can take a seat.
Okay. And then the next thing is, have you had a chance to have a chat about how long you think your submission is going to take?
Yes, my lady, my submissions are going to be around 30 minutes.
Okay.
And my learned friends are about the same.
All right.
Possibly a bit longer.
Possibly a bit longer, but in between may be a suitable moment for
yes, well, when you finish your submissions. Do you agree with that?
Yes.
Yeah, lovely. All right, great. Well, please start, Mr. Gray.
Well, may it please the court, I'm here on behalf of the appellants and AM, who of course have the best of an anonymity order. My learned friend Barnes appears on behalf of the Respondent, the Secretary of State. This is the appellant's appeal against the decision of the Upper Tribunal, the 13th of March 2025, dismissing their opinion from the First Tier Tribunal. Permission has been granted in respect of ground 1, and the application for permission in respect of ground 2 was adjourned to be determined at this hearing. With the court's leave, I propose to deal with ground 1 substantively,
yes,
and then deal with ground 2.
I think it's probably going to be convenient, Mr. Gray, if you just deal with ground 2, de bene SA, in the same way, and then we can decide. I mean, we're going to reserve judgment. We can decide when we do our judgments whether or not to give permission on ground 2. So I think it would just be more efficient if you deal with ground 2 on the hypothesis that you might get permission for it. Please.
Yes,
Is that all right?
my lady.
Lovely.
Before I delve into my submissions, may I check that the court has all the documents that it should have? The court should have the core hearing bundle, which runs to 65 pages. A supplementary bundle which runs to 266 pages. A bundle of authorities which contains 10 tabs. And runs to page 190.
For some reason, my supplementary hearing bundle, I think, runs to a bit more.
Has
than that.
more.
I think it's because there are two different numbers.
Oh, two different numbers, yes.
If you look at the bottom left,
Yes,
Yes,
confusing.
my lord is, of course, I say respectfully, right. And there's some confusion with the
Yes,
pagination.
I'd also failed to see the numbers on
I missed the bottom left numbers.
Yeah, not the obvious case one, but
But it is the pagination that starts with SB,
Yeah.
to which I'll be referring.
Well, thank
And
you
the
for
final
clearing that to
document is my supplementary skeleton argument dated the 8th of January, which was filed with the court's leave.
Yep.
At that point, I think my learned friend may have an application to hand up additional documents relating to the issues before the First Tier Tribunal.
Right.
There are a couple of documents I may seek to hand up during the course of my submissions, but I prefer to wait to see if they become relevant in due course, if I may.
Fair enough.
Well, if the application is made, I shan't oppose it because they are
You won't
documents.
oppose it. All right.
They're documents that I have seen and were plainly before the First Tier Tribunal.
Okay.
By way of introduction, the ladies, my lord. Ground 1 argues that the first tier tribunal failed to reach clear findings of fact in respect of the core elements of the appellant's claim said to be relevant to the assessment of risk. Rather, the tribunal reached a global credibility assessment in the abstract based on matters remote to the alleged events in Iraq, without explaining directly what it made of the evidence to the core of those claims. Ground 2, should permission be granted, concerns the tribunal's treatment of DM's evidence and whether the reasoning disclosed on the face of the decision entitles the informed reader to understand what weight, if any, was attached to his evidence on the core events. And although this is an appeal against the Upper Tribunal, my focus is going to be on the first tier tribunal's reasoning, because of course if the first tier decision is contaminated with material legal error, then it follows that the Upper Tribunal erred in law in dismissing the appeal. Very briefly, I will turn to what I say the material facts are. The first appellant is an Iraqi national from Erbil in the Kurdistan Autonomous Region of Iraq. The second appellant is her daughter. It is the appellant's case that she was betrothed to her maternal cousin, A, who she says has connections with the KDP, which is one of the ruling parties in Iraqi Kurdistan. But instead, going along with that marriage, she entered into a love marriage with DM, and following a relationship that they formed at university. At the time that they married, in 2016, A, that is her cousin, was absent from Iraq, having suffered a brain injury, and he was receiving treatment in Germany. The appellant's case is then that A returned to Iraq in 2021, made threats to the first appellant and her husband, came to their home with weapons, and threatened to abduct their daughter, the second appellant. The appellant's case is that if she goes back to Iraq, she will suffer similar treatment upon return. The Secretary of State rejected that account, and the appellant appealed, enjoying as she did a statutory right of appeal to the first tier tribunal. At that point, I would ask the court to turn up briefly the first tier tribunal's decision. That's the very last document in the core bundle, beginning core bundle 6. I'm not going to ask the tribunal, the court, to read the tribunal's decision in any detail now, because I will in any event return to it in my grounds.
Well, I should have actually made clear that we've all read both the determination of the FTT and the determination of the UT.
Well, that indication helps me shortcut matters substantially, my lady. But just a word on the structure.
Yeah.
The issues are identified at paragraph 5. A summary of the evidence then is at 7 and 8. An unimpeachable self-direction as to the law follows at 9 to 12, and at 13 to 20 is the tribunal's assessment of the discrete elements of the evidence that it took into account when reaching its global credibility findings at 21 and 22. 21 and 22 are, I will submit, the key passages of this decision, and I will take the court to them in some detail when I address ground 1. Now, before I turn to the grounds, I will say a word about the authorities. There is, I think it's clear, very little, if any, dispute between the parties as to what this court's duties are in respect of the second appeal, in respect of findings of fact. There's also little dispute in terms of the first tier tribunal's duties and the approach to be taken when credibility is at stake in the first tier tribunal. And it is a trite principle of asylum law that the standard of proof is one of a reasonable degree of likelihood, which is sometimes referred to as a lower standard of proof. And this same standard applies to the tribunal's assessment of past facts and in respect of future risk. I don't ask the court to turn it up, but that's clear from Civic Moran. It is also a trite principle of asylum law in cases in which credibility for witnesses at stake. That assessment is a global one to be taken in the round, which is to say that the tribunal of fact must take into account all of the material considerations and attach weight to it. This much is clear from the decisions of this court in JT Cameroon and in the Supreme Court in MA Somalia, with which I know this court will be well familiar. It is also well established that this court will not readily interfere with the findings of fact of the first tier tribunal. And again, I don't turn it up now, but that much is clear from the authorities of MAH Egypt and SB Sri Lanka. Now, there's also a well-established principle. The first tier tribunal is entitled to have its decisions read sympathetically, broadly, and not as if they are a statute. This court will necessarily be slow to find the tribunal has not given weight to a discrete piece of evidence simply because it is not referred to on the face of the decision. That is the principle involved. All of these principles, however, are not to say that the first tier tribunal's findings of fact are immune to challenge on appeal to this court. I will ask the court to turn up the authorities bundle behind tab 6. And this is the judgment of this court in SB Sri Lanka. The facts of the case are largely immaterial, but this concerned an individual of Sri Lanka who claimed to be associated with the rebel LTTE group and to be at risk upon return to Sri Lanka on that basis. The Court of Appeal considered the first tier tribunal's duties when assessing credibility of a witness, and the key passage that I would ask the court to read is 41 to 44. And that begins at page 101 of the authorities bundle.
Looking at the last sentence of paragraph 42, other pieces of evidence are remote from any indicia or proxy for risk, concern only whether the individual is telling the truth, which itself is then used in deciding whether the account of the risk posed by return is truthful. Isn't that what the judge did here? Doesn't that summarise what the first tier tribunal judge was doing?
Well, Well, plainly, I think I have to accept the points taken at paragraph 14 to 20 are potentially relevant to the overall assessment of credibility, in the sense of whether the tribunal is willing to attach weight to her evidence about things more generally. And my submission, when I turn to it, is going to be that what the tribunal has failed to do is grapple with the specific evidence dealing with what Lord Justice Green called proximate to the indicia of risk.
Thank you.
Yes. That passage in my submission condenses a number of propositions. The first relating to this court's deference to findings of fact. The second, to which my lady has already drawn my attention, the relevance of facts proximate and their significance to the global assessment when compared to those going directly to risk. And also, at 44, the tribunal's duties when tackling the most relevant pieces of evidence and the requirement to give reasons. And the next passage of this case, to which I'd ask to draw the court's attention, is 62 to 64. That authority sets out the tribunal's duties to give reasons, and that when the court or the tribunal fails to refer to relevant evidence or to assess relevant evidence, it follows there are inadequate reasons and an error of law. And that sets out the irreducible minimum standard of reasoning. And the next authority to which I'll take the court extremely briefly is behind tab 9. And this is another authority with which this court will no doubt be extremely familiar. It is WAS Pakistan. And the highlighted passage is page 165, paragraph 87.
waiting for my lady to finish.
Oh, sorry. Yeah, no.
No, you were right.
Yes,
please
maybe.
continue.
In short, a witness may be lying about one thing, but be telling the truth about another. And findings in respect of one discrete aspect of the claim cannot be generalised to all. And what is required is the fact finder to consider the intrinsic likelihood of the significant aspects of the claim. And the final authority in the bundle is TC Zimbabwe. And this is an Upper Tribunal determination from the President of the Upper Tribunal and the President of the First Tier, Mr Justice Dove, as he was there, and Upper Tribunal Judge Flimmer. This describes the Tribunal's duties to give reasons and the framework for a just determination. I would take the court paragraph 60 and 61, which again sets out the irreducible minimum.
Sorry, is the reference to the PS in paragraph 60, is that the practice statement?
That's the practice statement, yes.
Is there a better reference to it somewhere else in the judgment? Well, we don't need to take up time with it.
If it helps, my lady, it's referred to in the head note as the practice statement number 1 of 2022.
Thank you very much. Yes, sorry, I interrupted you, Mr.
And those principles are condensed in the appendix at paragraph 5 on page 189.
Sorry, what paragraph?
5.
Thank you.
Thank you.
I think we can agree, can't we, that he gave himself the appropriate directions on law.
Yes.
But your concern is with the other aspects of what's set out in paragraph 5.
Yes. And at paragraph 6, where there is apparently compelling evidence contrary to the conclusion which the judge proposes to reach, that must be addressed.
And I suppose paragraph 8 in this case, the reasons need refer only to the main issues and evidence in dispute.
Yes. Now, unless there's anything else in which the court wishes to be addressed in respect of the authorities, I propose to turn to the grounds. I'm just conscious that I've already gone for 25 minutes.
We've had one or two interruptions. Ms. Barnes, are you all right?
I'm fine, thank you very much.
Well, I hope that I won't be another 25, but of course, I'll be guided by the court in respect of
Sure.
an appropriate time.
Well,
for
let's see how we get on. But I think we can rely on Ms. Barnes to get up now and tell us if
I will.
she'd like a break.
Thank you.
Right. I'll turn then to ground one, that the tribunal failed to resolve a material dispute between the parties, failed to take into account material considerations, and failed to give adequate reasons to entitle the parties to know why they had won and lost. As a general submission, I will say this in the protection appeal, that the ultimate issue is not one of credibility. The ultimate issue is one of risk. The appellant's general credibility as a witness is only one part of the assessment and not the ultimate issue. Now, in this case, in my submission, the determinative question in respect of risk could only be answered by reaching conclusions, findings of fact in respect of the events that AM said caused her to leave Iraq. Those events are whether A returned to Iraq in 2021, whether A threatened AM and DM, whether he came to their house with weapons and threatened the second appellant, and whether a complaint was made to the police. The first tier tribunal must resolve the key factual issues necessary to answer the question in respect of risks.
Wouldn't that list also include whether he was a member of the KDP or involved somehow with the KDP?
Yes, my lady.
Bodyguard for politician within it or key figure within it?
Yes, my lady. Plainly that is
I
another
mean, that's
issue.
part of reporting to the police, but it is a separate matter as well.
Yes. Now, at that point, I will draw the court's attention to paragraphs 21 and 22. That is in the core bundle at page 64. I know the court has already read it, so I won't ask the court to read it again. But in my submission, there are a number of features to this paragraph which read both independently and in the context of the decision, arguably, or they do, disclose material legal error. And the sentence beginning about 6 lines from the bottom, where the tribunal says there may be aspects of her claim that are true, and I accept sometimes claimants will exaggerate. That's the self-direction. However, I do not find the appellant to be sufficiently credible to find that there is a reasonable degree of likelihood that her claimed fear is true. That, in my submission, is wrong for 2 interconnected reasons. The first is that it has not reached specific findings of fact in respect of those facts relevant to risk. And secondly, it does not entitle the reader to understand how the appellant's evidence going directly to those risk-bearing facts has been analysed. Instead, the judge has reached a conclusion on this appellant's general credibility as a witness, and then moved directly to the assessment of risk. That is to treat general credibility as a proxy for risk, rather than reaching the necessary factual findings. That, in my submission, is a clear break in the chain of reasoning necessary. The acknowledgement that there may be aspects of the claim that are true, in my submission, requires then the tribunal to state explicitly which aspects are made out to the required low standard that applies in asylum appeals. Now, it might be said, and I think indeed it will be said, that those paragraphs amount to an overall rejection of this appellant's evidence, and therefore it can be readily inferred implicitly that the tribunal has rejected her claims in respect of the chain of events that led to her leaving the country. In my submission, that approach cannot withstand reasoned scrutiny. The first reason for that is a simple one. It doesn't purport to be a wholesale rejection of the facts of her claim, because the tribunal says there may be aspects of her claim that are true. So this is not, as is sometimes the case, a witness who comes to the tribunal and the judge forms the view they're lying about everything. The judge has excluded that possibility on the face of the decision. And it might be suggested that if the decision is read as a whole, it's apparent that the judge knew what the issues are, and that is in fact a rejection. And instead I take the quote back, paragraph 5. The issues in dispute. Credibility of appellant 1, documentation 2.
Do we infer from that the parties expressly said to the FTT, oh yeah, we agree, there are only 2 issues in this case, credibility and documentation?
Yes. And I don't take the court to it, but the court has a transcript of what was said at the first tier tribunal.
Yes, I'm afraid I haven't read that.
And
that bears that out, does it?
yes. The judge at the beginning of the hearing says, my reading of the papers is credibility is the only issue. That's right, isn't it?
Right.
Not quite that, but words to that effect.
Right.
And the parties agreed with it.
Wow.
And indeed, that is supported by the 2 documents that a learned friend may wish to hand out.
Yeah.
But it's not contentious that that's what the way the parties framed their case. I'm simply at that point take the report back to the highlighted passages of 60 and 61 of TC. And that, I don't ask the court to turn it up because I think the court's already read it full. But that in essence says that it's for the tribunal. Indeed, the tribunal judge hearing the case has the ultimate issue, has the ultimate duty to round up the issues and to marshal the evidence. A proper approach I would submit would be for the judge to say, your skeleton argument says credibility is an issue. What findings of fact do you want me to make?
presented by counsel and the Secretary of State via a presenting officer.
Yes. And my third point as to why this cannot be regarded as a wholesale rejection of the pre-flight facts is that elsewhere in the decision, the judge does reject specific facts. And for example, at the very final passage of paragraph 22, he reaches a specific finding in respect of identity documents, which makes it clear in my submission that when the judge wanted to reject facts, he did. So in my submission, the first limb of ground one is made out as a simple failure to reach the required findings of fact.
What are we to make, if anything, of paragraph 13 of the University of Tribunal's judgment?
I think the point that was advanced below is that should be taken to be a conclusion that the appellant's evidence about pre-flight facts was accepted or reliable. And that's not a point that I make.
No, your point is rather different, isn't it? It is, look at what he said about that. Wasn't this the ideal opportunity to go on and make findings on these particular matters? Your point, I think, is that there's an absence of findings on key matters. You might have found that there weren't the inconsistencies that the Secretary of State had highlighted in the rejection letter, but he didn't go on then to make findings about these matters, and these were critical matters. Membership of KDP, not all the critical matters, but some of them are critical matters.
Quite, my lady. Quite. And when one does read paragraph 13, it rather gives the impression that the judge is negatively marking the script when it comes to credibility. So he only considers criticisms without considering the positive evidence called on behalf of the appellant. And that ties in neatly to my second strand in respect of ground one, which is that the matters relied upon to damage credibility were exclusively facts which were remote to the indicia of risk, and that there is no direct analysis on the face of the decision of the appellant's own evidence about what she says happened in Iraq leading to her departure. And at that point I will take the court to the issues identified by the judge at 14 to 20. I'll deal with them quite shortly. The first point, paragraph 14, is plainly relevant because it's a statutory consideration. So the tribunal cannot be faulted for taking that into account. What is potentially relevant is the judge's rejection of the appellant's reasons why she didn't claim asylum in France. And she says two reasons. The first of which is she said that because A had a Schengen visa, which tallies with him having been in Germany, he would have reach in France. And this is another reason perhaps why it cannot safely be inferred that the judge has rejected that fact. Because the reason why he rejects it is not because he says A couldn't reach her there, it's because there was effective state protection in France. The second point that's set to undermine the reliability or indeed the credibility of her evidence is at 15. This, I say respectfully, is perhaps quite an arcane point, but it is of what the appellant understands about her uncle's state of mind and whether he would assist her if she were to return to Iraq. Now that is not her uncle, that's her husband's uncle. The relevance of that appears to be exclusively to feasibility of return. Because that's the finding that follows that is the last one, paragraph 22, where the judge finds that the uncle could help them. So again, the uncle's state of mind and whether he would help them in other ways, having helped them to flee the country, is quite remote to the question of whether this appellant is credible in respect of events leading to her leaving Iraq. The third point is at 16. And that is that the appellant did not mention prior to the hearing before the first tier tribunal that her mother had also been threatened by A. That, in my submission, has to be put into its proper context. And I would ask the court to turn up in the supplemental bundle at 9 and 10, that's SB 9 and SB 10. And the relevant passages begin on page SB 9, lines 18 to 23. And then follows a series of other questions about that. And then on the following page, SB 10, at 32 to 35, she says in direct terms, that altercation at the house where A threatened my mother, that was over a land dispute, and that's not what led to us leaving the country.
Sorry, what lines were you referring to?
Close the file, but
don't
I'll turn it up again. That is
I think it's 32 to 35.
Okay,
lines 28 to 35
Thank you.
on page
10.
SB 10.
Thank you.
So again, on the evidence, that is remote to the indicia of risk. And the final point that the judge takes against the appellant is the lie that she told in her screening interview. That's at 18 to 20. Whilst a lie is undoubtedly relevant, it is relevant here to the assessment of civil documentation. And the judge indeed took the approach that was open to him following the Supreme Court's judgment in MA Somalia, in finding that the lie had a great bearing on her evidence about the identity document, and rejected it on that basis. But it is also clear from the structure of the decision that the judge siloed that issue away and dealt with it separately. And I'll return to my lady's point on that. There is no assessment about what the appellant said happened to her in Iraq. No assessment of the quality of her evidence directly on that point. all of these points are logically collateral to the points said to give rise to the appellant's fear of persecution in Iraq. And whilst I have to accept that, taken in the round, they're all matters that have the potential to undermine the appellant's credibility, there has to be some reasoned assessment to place them with the other evidence. So the account cannot be clear that the tribunal has taken into account and attached weight to what she says happened in Iraq. And so in my submission, for those two reasons, ground one is made out. With the court's leave, I propose to move on to round two.
Yes, please.
I will deal with this relatively shortly because it is, in any event, subsidiary to ground one. It is that the First Tier Tribunal failed to directly address the evidence called by D. I will ask the court to turn up in the supplementary bundle DM's witness statement. That is at SB 36. Now, DM was a primary witness of fact. He was in Iraq and he saw these events happening with his own eyes. And he explains in that statement a number of facts which are relevant to the assessment of risk, including how he came to know of the engagement to A, about A's return to Kurdistan in February 2021, an incident in February or March when A came to his place of work with members of the Civil Defence Committee, at which ladies, my lords, is relevant to that issue of whether A was affiliated with the KDP. He describes receiving threatening phone calls from A. He describes armed men coming to the home. He explains lodging the complaint at the police station. And he describes not being in contact with relatives in Iraq and the reasons for it. And this evidence in my submission goes to the core issue, which is risk, because it speaks to the risk-bearing events that happened leading to the appellants leaving Iraq. At the hearing, and I will ask the court to turn briefly to the transcript of the evidence. SB 18. It's internal page 17 of the transcript. At lines 18 to 25. The court will, of course, remember that at paragraph 15 of the First Tier Tribunal decision, the lack of contact and willingness of the uncle to support the family if it returned to Iraq was regarded as one of the key things undermining credibility. Of course, D was better placed than AM to talk about the state of his relationship with his uncle, because he's the one that had direct contact with him. And what he describes there is that the uncle stopped associating with him because he was frightened and sought to distance himself from the source of the danger. The source of the danger here being AM. That the uncle took a calculated risk, exposing himself to that limited danger, but not wanting to put himself at greater danger if he was proximate to them in Iraq. That evidence in my submission is absolutely key, because one of the matters regarded as a core failing in AM's evidence is her unreliable evidence about that. The judge is obliged in my submission to deal with the core evidence about each discrete finding. Here, that is D's evidence. That alone, in my submission, is a failing in the first tier decision. But more broadly, the only topic of D's evidence that the tribunal directly addresses is in respect of their identity documents. That is at the base of paragraph 19, which is at CV 64. And it is the final sentence. That is the only place of D's evidence as it relates to the tribunal's assessment of the credibility of the claim.
There was no indication of respects in which the FTT found the evidence to be inconsistent and unconvincing.
Quite, to some extent, that's evidence. So he's immediately qualifying it, which cannot be regarded in my which cannot be regarded in my submission as a wholesale rejection. And so the reader cannot have any confidence that that evidence has been weighed in the mix at all. Particularly bearing in mind the issue identified at 5 is exclusively AM's evidence and the credibility of it. And so in my submission, ground 2 is not only arguable, it is also made out. Now, I appreciate now I've got a double lifetime estimate at Milady, my lord.
It's all right. It's notoriously difficult, particularly when you're being asked questions. So that's fine.
But that may be a convenient moment for a break.
Yes, Ms. Barnes, would you like to have a break now?
Yes, if we can, but only 5 minutes as far as I'm concerned.
All right, lovely. Well, that's fine. We'll rise for 5 minutes. Thank you.
Thank you.
Just to let you know, I'm keeping the live stream on.
Try not to say anything prejudicial.
I'm just going to put them on.
know.
Yes.
I should have said.
Is there anything else on which I can assist?
Oh, no, that's, I don't think so. No.
In that case, those are my submissions.
Thank you very much. Yes, Miss Barnes.
My lady, beginning with ground one, I don't propose to address you on the general legal principles underpinning the approach to credibility in an asylum context. As Mr. Greer set out at the start of his submissions, there is little between the parties on that. Instead, I propose to focus my submissions on the application of those principles to the facts of this case. The appellant's central complaint in this case is that in undertaking the FTT, in undertaking its purported global assessment of credibility, failed to make findings on the core disputed facts and relied on matters peripheral to the assessment of risk. And the Secretary of State's case is that criticism is unjustified, and I propose to make 5 broad points in response, if I may. And the first 2 points are really contextual points about the nature of the claim, but in my submission they are important to understanding the way in which the first tier went about making its decision. So first point is that this is a case that turns solely on the credibility of the appellant and her husband, and therefore there is a very close link between the first tier tribunal's credibility assessment and its findings of fact as to risk of persecution. So this is not a case where the appellant sought to rely upon documentary evidence to support the plausibility of her claim, such as, say, written communications between her and her family, or an arrest warrant suggesting that A had managed to escalate matters. Nor was there any expert evidence, as one often encounters in these cases, bolstering the appellant's account. And finally, the country background and general background evidence as to Iraq did not take matters any further. So the success of this claim entirely stood or fell on whether the appellant's account of her reasons for leaving Iraq were considered to be credible, applying the lower standard of proof. And the focus on credibility is made clear in the issues, the articulation of the issues set out in paragraph 5 of the first tier tribunal's decision. This is a point my lady has already picked up on, but to the extent there is some criticism of the articulation of those issues, that criticism is unwarranted because it was how the case was presented to it.
Well, I'm not sure it necessarily follows that criticism is unwarranted. It's the tribunal's job independently to work out what the issues are, and not just to rubber stamp the parties.
That is of course true. I accept the tribunal isn't merely a sort of passive vehicle in all of this, but it is important in my submission to understand precisely how the case was put by the parties at the time.
Because I've seen lots of cases where agreements by the parties about what the issues are have ended up leading the tribunals and courts off-piste.
Yes, so have I, my lady. But perhaps I could just I don't think the point is in dispute, but perhaps I could just hand up the 2 documents I'm referring to.
You don't object to this, do you, Mr. Gray?
No, my lady.
The first is the appellant's skeleton argument prepared for the first tier proceedings, and the second is the respondent's review. So if one begins with the appellant's skeleton argument, paragraph 6 on page 2 sets out the appellant's clarification of the issues as the credibility of appellant A1 and then 2 documentation. And then if one looks at the respondent's review, you see that schedule of issues repeated on the top of page 2 under a subheading of B, schedule of issues.
Because it might be more accurate to say that the issue is the credibility of the key aspects of the appellant's account, which is a bit different from the credibility of the appellant in the abstract.
Yes. So one of the points I will come on to make is that in my submission, in a case such as this, turning solely on the credibility of the appellant's account, the first tier tribunal was entitled to come to an adverse global credibility finding on the points that it did. But yes, I do accept my lady's point that it was for the tribunal to re-articulate the issues should it so wish, but I certainly make the point that the tribunal wasn't particularly assisted by the appellant's position taken before it.
But I mean, that's really not an excuse for the FTT because appellants are sometimes not represented very competently at all, and it's not for the FTT just to throw up its hands and say, oh well, I'll just go along with this incompetent representation. The FTT's got a job to do.
No, and that point I accept too. I'm not sure it's necessary to turn up, my lady, but it is also clear that those issues in dispute are confirmed by the judge at the start of the hearing, and I can provide the transcript reference should you want to see it. Yes. The second point I would seek to make by way of context is that in my submission this is not a case where there are very clear discrete aspects to the claim. And I say that in contrast to, for example, someone who claims a well-founded fear of persecution arising out of, firstly, events that took place before they fled to the UK, and second, separately, their surplus activities in the UK. So in my submission, this case all stemmed from the appellant's claim to being threatened by A, and it was that which led to her fear to be at risk on return. So in my submission, that was the core fact on which the first tier tribunal was required to come to a conclusion on applying the lower standard of proof. And the judge, again, bearing in mind how the case was presented to the first tier tribunal by the appellant as to the two issues said to require resolution, the judge does make findings on those two key issues in paragraph 22 of the decision, which you've already been taken to, my ladies and my lord, but perhaps we could just turn it up again. It's page 64 of the core bundle. Do tab references assist the court or not particularly?
Not particularly.
Thank you. Page 64, paragraph 22 of the judgment. and it's really 4 lines from the bottom. I do not find the appellant to be sufficiently credible to find that there is a reasonable degree of likelihood that her claimed fear is true. Similarly, and for the reasons given above, I do not accept that she could not access the family documentation if returned. So those were 2, I appreciate, phrased quite generically, but findings of fact on the key points, key issues as they were crystallised before the tribunal. And in respect to the point about her claimed fear, in my submission, that does need to be read with paragraph 4, where her claimed fear is set out, namely that she would be the subject of an honour killing in light of the threats that A had made to her and her family prior to her departure from Iraq.
How does that sit with what is said at the beginning of that sentence? Namely, there may be aspects of her claim that are true.
Well,
Do we find that these are sort of irrelevant aspects of her claim?
well, in my submission,
Make clear whether they're relevant or irrelevant aspects of the claim.
I do accept it could be clearer, and if there had been more detailed reasons, perhaps I wouldn't be before you, my lady, today. But in my submission, where it's referring to those aspects of the there may be aspects of her claim that are true, that really ties back to what is set out in paragraph 13, where the tribunal rejects the Secretary of State's submissions as to aspects of her account lacking credibility in other material respects. So, for example, in relation to whether A was a member of the KDP, the first tier tribunal rejects the submission that she lacked credibility, or there was an inconsistency in her account on that. And
well, I mean, I think one must be precise about what paragraph 13 finds. It does not find that she was credible on those. It just says, it just negatively finds that it's not something that the respondent can rely on, that the Secretary of State.
well,
It says it's not an inconsistency as identified by the Secretary of State, but it doesn't go on to say, and I find that she was credible on this point.
well,
Or are we to?
The only point I would refer my lady to is 13D. For the reasons above, I do not find that the above inconsistencies damage the appellant's credibility.
Yes. Well, is that a neutral, or is he finding that that he does agree with those? Is he just finding that they're not inconsistencies which damaged her credibility, or is he finding these are matters that he's prepared to accept? Because actually, each of these matters, A, B, and C, are important to her claim that there's a risk to her. They don't include the occasion where she said he came round with gunmen and threatened her and her daughter. But they include pretty much everything else that forms the basis of her account, don't they?
Yes, and I accept that. I suppose the point I would make is that when one reads the judgment as a whole with paragraph 4 and 13, and then that comment in paragraph 20 about some aspects of the claim being true, essentially what the finding that the judge is making is that in respect to those facts set out in paragraph 13, he is satisfied as to the appellant's credibility, but in respect to the points that are then articulated in further detail at 14 to 17, those are the aspects of the claim that are said to damage her credibility.
But what's potentially unsatisfactory about paragraph 13 is that in 2 cases, the FTT suggests that it's going to go on and make findings of fact about the account. So last sentence of 13A, should I accept the appellant's account, the fact that the family is really blah, 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 does not exclude the possibility of A being blah, blah, blah. Well, but that's just left hanging in the air because the FTT doesn't make any findings of fact on that point. And a similar point applies to the last sentence of paragraph 13B. if I accept her account, this is not an inconsistency.
But in my submission, that has to be read with the ultimate conclusion that that he does not accept the appellant's account.
Well, we have a repeat in C as well, don't we? Right in the middle. If the essential facts are accepted.
Yes, in my submission, what he, and I, as I say, I appreciate it could be clearer, but what he does go on to ultimately find is that the essential facts are not accepted because of the points he makes about her credibility being damaged in a number of very significant significant ways.
It's just curious that in this paragraph, the FTT appears to understand that it's got to make findings of fact about the account, but then doesn't do so. Makes no findings of fact at all. It just simply says, oh, well, I'm slightly oversimplifying. Oh, she's not credible, therefore there's no risk.
Well, in my submission, that it is implicit where the decision is that she is not said to be credible, that her account of being threatened by A is not accepted by the FTT.
If you're right about that, then we shouldn't be looking back to paragraph 13 to get a hint of what he means by there are some aspects of her claim which may be true, or that are true. There may be aspects of her claim which are true. When I asked you what he might have meant about that, you referred me back to 13. But now we're at the place where he's rejected all of 13.
Well, I apologise. I don't think I've been very clear. In my reading of the judgment and the submission I seek to make is that where he is referring to aspects of her claim that may be true, he is referring to the matters in 13 in which he has not made an adverse credibility finding. But overall, in respect to her key claim to be at risk from A because of the threats he has allegedly made to the appellant, the FTT has found that he made a finding that those facts are not made out because of the adverse credibility findings he makes in the interim passage within the decision.
We certainly don't know whether the FTT accepted that A was in the KDP. We don't know whether the FTT accepted that she might be at risk of an honour crime, and we don't know whether the FTT accepted that the KDP had reached across Iraq to threaten the appellant. We're just left.
Well, it is true. You don't know for certain. You don't know for certain whether the FTT concluded that he was a member of the KDP or the KDP had reach across Iraq, though there is nothing in the judgment to suggest he was concluding to the contrary. What you do know is that he does not consider her to be at risk of an honour killing and therefore there to be a reasonable possibility of persecution on her return.
But if the FTT had accepted the points in 13A, B and C, the appellant might have had a run at real risk on return.
Well, not if the FTT, my lady, not if the FTT fundamentally didn't accept her account of being threatened, because then it would be immaterial whether or not he was a member of the KDP or not. And that is the key finding in my submission. That
Except that we're left with this puzzle because 13A, should I accept the appellant's account, does not exclude the possibility of A being sufficiently aggrieved to threaten the appellant, and he did. So there's the FTT accepting that that's a logical possibility and just not making an express finding that it didn't happen to the lower standard.
Yeah, I mean 13A is making clear that the point alone that the family initially agreed to the marriage to D does not rule out the possibility of A being sufficiently aggrieved to threaten the appellant, as she claims he did. But in my submission, that doesn't detract from his ultimate conclusion that A ultimately did not threaten the appellant, otherwise there would be a real risk of persecution on return.
Can you show us a passage anywhere in the FTT's determination where the FTT clearly say, I do not accept to the lower standard that AN threatened the appellant?
No, I can't, my lady. One has to read paragraph 22 and the claim and the tribunal's conclusion that he did not find there was a reasonable degree of likelihood that her claimed fear is true, with paragraph 4 and what is set out there as to her claimed fear being the threats from A.
All right.
The third point I wish to make was that the first-tier tribunal was entitled to come to the adverse credibility findings that it did. And if I could ask you just briefly to turn up the decision of this court in SB Sri Lanka. You've already been referred to it, but it's the authorities bundle, page 93 is where it begins. That's the start of the authority, but the relevant passage for our purposes is at paragraph 41 onwards, page 101 of the authorities bundle. Paragraphs 41 and 42 you've already been referred to, and my lady made the point about the final sentence of paragraph 42. Did that not have relevance to this case? And in my submission, the different types of evidence do fall within that category. And Lord Justice Green was not suggesting there was necessarily any less value in this type of evidence. Paragraph 45 deals with the deference to be given to a tribunal judge in this context, a point I will very briefly return to at the end of my submissions. And then paragraph 46 talks about the evaluative techniques used to assess the credibility of an appellant, not intended as an exhaustive list, but these were the techniques used by the first-tier tribunal in this case, and in particular, Roman numerals 1, 2, and 5, 3 and 4 having less bearing. But in particular, the consistency of the appellant's account in significant respects assumed particular prominence in the first-tier tribunal's findings. And I don't know if it is helpful to identify briefly the 4 areas which the first-tier tribunal did conclude damaged the appellant's overall credibility. They are set out at paragraph 9 of my skeleton, but I can briefly go through them unless the court already has those points.
By all means,
I'll take them
develop them.
relatively swiftly. The first is the failure to claim, if we return back to the...
This is the section 8 point.
Exactly, the section 8 point. And I simply remind you of the court's comments in JT Cameroon, Authorities Bundle, tab 3, page 54, paragraph 21, where section 8 matters are held to be entitled to some weight. The weight to be given to them is entirely a matter for the fact finder.
What paragraph of JT Cameron was that?
It's paragraph 21, page 61 of the Authorities Bundle. The second point relied upon is the implausibility, effectively, as to the role played by Dee's uncle. Essentially, the point being made that it was implausible that Dee's uncle would not assist the appellant further because he feared being associated with her when he had already assisted their escape and already had an association with them.
Speaking for myself, I'm not sure that is terribly implausible. People are complicated and they might be prepared to go so far and then think, blimey, that's enough.
Well, I accept that point, but in my submission, this is the type of area where, with respect, due deference needs to be given to the
Good point.
tribunal judge hearing, because what the tribunal says is, I found the appellant's answers at the hearing to be unconvincing on this issue. And he had the benefit of hearing from both the appellant and the husband on that point, to which I'll return in the course of ground 2. Third is the failure to mention, or the appellant's failure to mention the threats to her mother prior to giving evidence at the first tier tribunal. And that was addressed at paragraph 16 of the FTT's decision. But if I could just briefly trace through with the court how the appellant's evidence changed on this, what I say is an important issue. We have in the supplementary bundle the appellant's asylum interview. If one turns to page 214 of the bundle, that is the start of the appellant's asylum interview, but the relevant question is question 34, which one finds at page 225. Near the top punch hole, have your family members experienced any persecution? Response, just myself, so I had to leave.
Was there a correction letter or wasn't the record of interview passed by the representatives who?
You're exactly right, my lady. If
There
one
was some mention of this in, maybe it didn't help, but there was some pick up on this point in the letter, wasn't there? Can't find it. No, I should have marked it.
I was going to say to the contrary, I believe a list of corrections were provided by the appellant solicitor which didn't deal with this point, but I think
There was
it's,
some correction to a name, wasn't there?
yes, I think it might be, give me one moment.
It's at page 39 of the supplementary bundle.
Thank you.
Thank you.
Yes, so thank you, Mr. Greer. Those are the clarifications given by the appellant solicitors after the asylum interview. There is no mention there of that answer in any way being inaccurate. Is that the document you were thinking
It
of, my
was,
lady?
yes, yes. The one I was thinking of was the last, the issue relating to the inheritance and the money that his mother received reignited the conflict with the parents.
Yes. just continuing to trace the evidence through, if I may, we then have the appellant's witness statement prepared for the hearing, which is supplementary bundle, page 32. And the appellant deals with the threats received at paragraphs 17 to 18 on page 34. The point I obviously make is there's no mention there of any threats made to her mother. So the first time that the mention is made of threats made to the mother is in her oral evidence before the first tier tribunal, and perhaps it's helpful just to turn that up to see precisely what the appellant said. So it's SB page 9. It's really lines 14 to 20, but in particular line 20, you see the reference to the appellant, the A also threatening the appellant's mother. And just so you see the full evidence on the point over the page, lines 19 to 31, you see it being put to her that that was a allegation that had not been made previously, and the appellant's response to that. And the fourth and final area in which the appellant was found to lack credibility concerned the inconsistencies surrounding her identity documentation. Specifically, that she had lied in her screening interview when stating, "I left my passport at home in Iraq." You might not need to turn that up, but for your reference, it's question 1.8 of the screening interview, which you have in the supplementary bundle at page 240. That was the position she took in her screening interview, in contrast to the position she took from the point of her asylum interview onwards, when she said she had been carrying both her passport and her identity card, but they were taken by the agent in Turkey, who said he would take them back to Iraq.
That's at 220, I think.
Yes. And the explanation for that lie given in the screening interview was only first provided at the first tier tribunal hearing. Was at that point, for the first time, she said, "Oh, I said that in my screening interview because I was told to say that by the smuggler, and she was scared of the smuggler." And that was not something she had mentioned in either her asylum interview or her witness evidence. And nor did D, her husband, say anything about being told to say the passports were in Iraq. So in my submission, those were 4 clear areas in which the first-tier tribunal was entitled to come to adverse credibility findings. And therefore the upper tribunal, which is a decision we haven't really looked at all so far, but the upper tribunal, in dismissing the appeal, what it essentially, or in fact what it did say at paragraph 12, which is page 47 of the authorities bundle. Sorry, page 47 of the core bundle, yes. Apologies.
Paragraph 12, did you
Yes.
say?
We do not find the grounds to be made out, whilst the judge's decision could arguably have been better expressed and formulated. It is clear that his adverse credibility findings were based upon a global assessment of the evidence, drawing together various strands of reasoning, as he made clear at 14 and 21. So that was my third point, that the judge was entitled to make those adverse credibility findings. My fourth point is that I do not accept the appellant's characterisation of those matters relied upon as somehow peripheral to the claim or remote from the indica of risk. That is contrary to the first tier tribunal's finding at paragraph 22, page 65, and I apologise for all the flicking about between pages of the bundle. Where what the tribunal says is that I find that those areas where I found the appellant's credibility to be damaged were some of the key aspects of her claim. That is a finding in my submission the first tier tribunal was entitled to make, and a similar point is made by the tribunal, upper tribunal, with all their institutional expertise at paragraph 14 of their judgment. Just to briefly return to that, if we may. Paragraph 14, it's page 48 of the bundle. I'd ask you to read the first 2 sentences of that paragraph.
Did he conclude that the husband wasn't a reliable witness? Where's that conclusion in the FTT decision?
Well, I will return to this in the course of ground 2, but
Okay.
I'm happy to deal with the point now because what is said on in respect to D's evidence is, firstly, he is found to be an unreliable witness in respect to what he said about the passports being returned to Iraq, or at least there's an inconsistency between the appellant's evidence and D's evidence on that point, which is noted at the end of paragraph 18.
Yes, oh quite. But one sense is that the FTT judge is using what he said as a reason to doubt her credibility, not as a reason to doubt his.
Well, in my submission, I suppose where they are both inconsistent, it bears on both witnesses' credibility.
Depending on which way you read it.
Yes.
It's not very clear.
I think I've made the points on that
Yes.
that I can, but and just to finish off this point about what is said about Dee's evidence, is also
But this is sorry to interrupt, but this is Mr. Greer's point, isn't it? That the Upper Tribunal saying that the first tier tribunal rejected his evidence as credible, the only passage which we can find that in is the bit where he deals with documentation. He doesn't make any comment at all upon what Dee says about the events leading to their departure from Iraq.
No.
And he gives a very full account of that in his witness statement.
well, he certainly gives an account of it in his witness statement. I suppose I might take respectful issue with the characterisation of it
Well,
as
he gives an account
full,
of it
but
in
yes,
his witness statement.
he certainly does give an account of it. Again, I will briefly deal with this in the course of ground 2, but in my submission it didn't take the evidence of the appellants, the evidence of the first appellant much further.
No, but given that he was also a direct, I mean, it would be different if he was giving evidence of what the appellant had said to him. Then of course her credibility would be key to that because she's telling him about things that had happened. But where you have independent evidence of eyewitness evidence of events that are said to have happened, isn't he obliged to deal with that?
Well,
Consider that separately. It's not just her account. What Dee says is a separate account which matches hers of what took place requiring them to leave.
yeah, and I accept the force of those points. What I would say in response is that the first tier tribunal clearly does have Dee's evidence in mind. It notes a specific inconsistency between Dee's Dee's evidence and the appellant's evidence, and also refers to it being inconsistent and unconvincing to some extent.
It doesn't refer to a specific inconsistency, and if you read that sentence carefully, what the FTC is saying is that it finds the evidence of the appellant and to some extent that evidence provided by AN alongside evidence to be inconsistent and unconvincing. So as far as the evidence of AN goes, it's only inconsistent and unconvincing to some extent, but the final bit of the sentence uses that to damage the credibility of A1. He doesn't, the FTC doesn't say anything about the effect of that on the evidence of AN.
No, I accept we have nothing more than the finding that AN's evidence is to some extent inconsistent and unconvincing. And then we have the specific inconsistency that is referred to in the context of the documentation at the end of paragraph 18, but that is the sum total of it. I can't magic up more,
No.
unfortunately.
That's very right.
Just returning to where I was in the course of ground 1, I just wanted to briefly address the 4 points in turn as to why, in my submission, they can't possibly be properly characterised as peripheral. Taking them in a slightly different order from what I did previously, the most obvious one in my submission, which is central to the assessment of risk, is the threats made to the appellant's mother. Because that was directly relevant to the question of the extent of the threats made by A and the reasons the appellants decided to leave Iraq in the first place. And one can't say, as the appellant has tried, that it related to an entirely separate land issue. Indeed, the appellant's own evidence seemed to conflate all these threats, or the two issues, into one. And if I can just briefly make good that point by reference to the underlying evidence. One has the her record of asylum interview back in the supplementary bundle, page 230, if I may. It's a question about the threats made. And what she said at the end of that question is, when he came back at the beginning of February, he sent a threat through my maternal uncle. These lands should be redistributed because my mother received a good compensation. The appellant will not get away with that marriage. So the threats being made to A, it doesn't appear to be two entirely distinct and separate topics, but rather the threats are being made for both those issues. One, the land, and two, the appellant's marriage. And it's actually perhaps even clearer when one looks at how the appellant dealt with it in her evidence. I could ask you to turn page 9 of the supplementary bundle, which is back in the transcript. This question as to the issue as to the land is really dealt with between lines 7 to 22. But if I could draw your attention particularly to lines 20 to 22 and her answer, this is what the appellant, A was said to threaten the appellant about. He said to my mother, started threatening my mother. He started talking about dividing the lands. The lands have to be divided again. And the case of the, I skirt over the appellant's Christian name, again is related and is ongoing. So she herself is saying that the cousin was saying that the two issues were related.
See further down why they're related, because on her account, my mother, she wasn't well, she'd registered the land in my name.
Yes, yeah. In my submission, that's grist to my mill as to why one can't seek to diminish this point about the threats to the mother as merely a peripheral issue to the indica of risk, because the threats were all part and parcel of each other. So that is the first point. The second point is the question of the documentation and the assistance provided by Dee's uncle. And Mr. Greer said, well, that purely went to the feasibility of return. But again, in my submission, that slightly misses the point, or indeed this is the point made by the Upper Tribunal, paragraph 15, when they were considering the relevance of this adverse credibility finding. What they say, page 48 of the core bundle, paragraph 15, sort of bottom 7 lines, the relevance of the matter was not the ability to access identity or documentation, but rather the fact that the appellant had given inconsistent evidence in relation to the issue. I think actually I didn't read that out very helpfully. One really needs to read paragraph 15 in its entirety, but that is the point being made that...
Would you like us to read it?
Yes,
now?
and I'll be quiet.
Why don't you do that? Thank you.
Don't you sit down while we do that.
Thank you.
I've just picked up from the very last line of paragraph 15 that the FTT judge is a she, not a he. Is that
Yeah.
right?
I think, do you know, halfway through my submissions, my lady, I thought I've got no idea whether this judge is
No,
male or
it's
female.
It's a he.
Oh, it's a he. Oh, so
Kira.
this is a typo then.
Because I wondered if I'd been mislabeling them throughout, but
Yes,
thank you for the
okay, so
clarification.
My lord is of course right, it's a Kira.
Thank you. Right, well, thank you both for clearing that up. Yeah.
And then the final point relied on was the Section 8 point, which, as Mr. Greer fairly recognised, that is something, Section 8 matters is something which the tribunal is statutorily required to consider.
Yeah.
So my submission, these aren't peripheral matters that can be swept to the side. They did turn or go to the central issue as to the appellant's account of being threatened by A and whether she would be at risk on return. And the fifth and final point I wish to make in ground one, and I won't labour the point, is that the appellate courts have repeatedly emphasised the need to exercise due caution before intervening in a case of this type. And as I said, in the most polite and respectful manner, that would be the thrust of the submission.
Yeah, well, I think we've got that message loud and clear.
Thank you. That was all I wish to say on ground one. If I can turn to ground two, and if hoping that you wouldn't take it as an admission of defeat, would you mind if I sit down for my submissions on
absolutely not.
submissions on this? I think, my lady, I can deal with the point relatively shortly because I've already answered some questions on it.
Do you want to take your wig off? Would you be more comfortable? Are you feeling a bit hot?
I am quite hot.
Yes,
Thank you
well,
very
that's-
much. I think I can deal with the point quite swiftly because I've already answered a number of questions on what the FTT said in respect to D's evidence. And I have noted the passages where it is dealt with. Paragraph 7, where the FTT noted the fact that D gave evidence and was cross-examined. Paragraph 18, where the judge specifically refers to the inconsistency as between the appellant's evidence and D's evidence as to what the smuggler told them to say as to their passports remaining in Iraq. And then paragraph 19, as to the overall assessment of D's evidence. But if I could deal briefly with the specific criticism, because this was the point that my learned friend focused in on, that the FTT in particular did not address D's evidence as to the reasons why his uncle had cut off contact. In my submission, when one actually looks at the evidence given by D on this issue, it is hard to see how that evidence took the appellant's case any further. Or to use the language of the practice statement, which you were referred to in the course of the final authority in the authorities bundle, it didn't amount to compelling evidence contrary to the conclusion which the judge proposes to reach. And therefore there wasn't an obligation on the FTT specifically to deal with it. And perhaps I could just, again, with apologies for all the flitting between various bundles, deal with the two parts of the transcript where first the appellant and then D deals with this question of the change in willingness of the uncle. The appellant's evidence is on this point is page 7 of the supplementary bundle. It begins at line 3, and it has to be said, it's not the easiest evidence to follow, but perhaps I could ask the court to read page 7, and then it is dealt with a little further over the page up until line 22 of page 8.
Sorry, can you just remind me where you'd like us to start, please?
Yeah,
Line, did you say?
of course, page 7, line 3, where you have a question about
Yeah.
the uncle not wanting to be associated with the family. What do you mean by that?
Right.
Thank you.
I would say it's not enormously clear, is it?
No.
They were
No,
the area they were travelling through.
I entirely agree, my lady. I think the closest one gets to a explanation from the appellant is probably page 8, and then lines 12 to 16, where she seems to be saying that, well, previously the uncle was only associated with the appellant and her husband, and he did not want to be associated with what I take to be the broader family. But as I caveated at the beginning, it is not the clearest evidence to follow.
Well, the answer is really at 19 and 20, lines 19 and 20 on SB8, isn't it? He was putting himself at risk. For that reason, he stopped the contact with us.
Yes, I suppose yes, I take that point. I suppose the rhetorical question I would put in response to that is it doesn't really explain why he would be happy to put himself at risk in terms of organising.
No. Then you're getting into what he thought, and quite
Which was exactly the point.
getting to her giving evidence of what the uncle might have thought.
Yes, yeah. But that was how it was dealt with by the appellant. And just dealing briefly, I think you've already been taken to this, so we can again take it quite shortly. What the husband D said about it, you'll see it page 18 of the supplementary bundle. This one is thankfully a little shorter. It's really dealt with page 18, lines 14 to 25. And in my submission, Mr. Greer put a nice, like a bit barristerial gloss on what was said there. He said, well, this is D saying that his uncle took a calculated risk exposing himself to the limited danger, but not wanting to put himself in greater danger. But in my submission, the evidence isn't particularly clear, and there's really no explanation for why he would feel able, the uncle would feel able to help them leave the country and organise and pay for their travel with a smuggler, but then cut off all contact, or significantly how A would even know if D's uncle had remained in contact. So that was the specific factual point I wish to address. On ground 2, I do accept that the reasoning could have been greater, but in my submission it's not so deficient to amount to a error of law, reminding the court of Lord Justice Lewison's comments in Volpe and Volpe, which you were referred to, my learned friend, at the start, that reasons could always have been better expressed. But that the judge did clearly have these evidence in mind. Unless you had any questions for me, that was all I wished to say. In fact, apologies, I should check with my... Yeah, that was everything.
All right, thank you very much indeed.
Thank you.
Yes, Mr. Gray.
Unless there's anything on which I can assist the tribunal, I have no submissions in reply.
All right, no, thank you both very much indeed for your very clear and commendably succinct submissions. We're very grateful for the work you've done to prepare for this, and I expect other people, I've seen, to have helped you as well, so we're grateful for everything that's gone into the presentation of this appeal. As I indicated earlier, we're going to reserve our judgments, and they'll be circulated in draft in due course, and that's for the purposes of correcting obvious mistakes like typos, but not for the purpose of re-arguing the cases, I'm sure you both know. Please bear in mind that the draft is subject to a very fierce embargo, and that there are consequences from breaking the embargo, as is clear from the Council General of Wales case, which I'm sure you're also very familiar with. In due course, once we've circulated the draft judgment, please could you do your best to agree a draft order. If you're not able to agree a draft order, we'll deal with any submissions about any disagreements in writing, please. And after that, the judgment will be handed down electronically, as it's now practice, so you won't need to come back to court for that purpose. So thank you both very much indeed.
Court rise available.